o'clock, we can go ahead and get started. And my name is Charioty James. I'm an attorney with James and Parlange Law. And I wanted to talk to you a little bit this morning about estate planning and probate in Texas, and hopefully some tips to help you avoid a full probate. Normally when I talk on these topics at conferences, I am in a situation where I'm live and I have a live audience. And not only is that good for me, I would much rather be in front of a live audience than I had a computer screen, but it's typically better for the audience also because I take questions all during the presentation. And so I'm happy to stop along the way and answer any questions. If you are watching live right now, there is a chat screen and you are welcome to ask questions at any point in time on that chat screen. I'll try to remember to keep an eye on it. And if for some reason you're not able to answer or ask your questions for me to answer, at the end of my talk, I'm going to pull out a list of the most frequently asked questions that I get when I'm doing these. Hopefully, if you haven't been able to ask your questions, there I am. For some reason, my picture went off, but hopefully we'll resolve that. Now, if for some reason you're not able to ask your question, hopefully I will answer it at the end of the talk. So hang in there and we'll get to it. Good morning, Sandy. I see you. Thanks for letting me know that I can see those chats. So in order to understand estate planning, it really is important to understand the probate process in Texas, because that's kind of what drives us as attorneys on how we help you prepare for probate. So if you're looking at your screen there, you can see I have a PowerPoint for you to look at with some different, there we go, with some different parts of the probate process. So when you pass away in the state of Texas, you're either going to pass away intestate or testate. Now, what that means is if you pass away intestate, you do not have a will. And you will hear me say several times throughout this presentation, you don't want to be in that situation, but don't panic. I know a lot of you out there are caregivers, and you may be in a situation where you are caring for a person that no longer has capacity to be able to execute a will or sign a will. And capacity just means that they would not understand what it is that they're signing. So don't despair. There is a process that you can go through whenever that person passes away without a will. And I'm going to go through that and tell you how that process works. But by all means, if you do have capacity or the loved one that you are caring for has capacity to sign a will, have them do that right away. It really is important. It makes it cheaper to be able to do the probate and a whole lot easier. And you'll see that as we go along. So intestate is passing away without a will. Intestate just means that you've passed away and you did prepare a will and execute a will before you died. So we're going to talk first about the intestate process. For those of you that have that person that you're caring for, and signing a will is no longer an option. So there are two parts to an intestate probate, okay? You have the heirship proceeding and the administration of the estate. Now, the heirship proceeding is where a court determines who the heirs are, who is going to inherit the property in the estate. And that is can be a real complicated process. I'm showing you here a little diagram that just, and you don't have to understand this diagram, this just gives you an example of whenever the court is determining who the heirs are that are going to inherit someone's property, it matters if the property is community property or separate property, meaning did the person that passed away acquire that property before they were married or during a marriage, because that changes how the property is going to go. And you can see you have different diagrams for married with children, married without children, a single person. So it can get very, very complicated. So, another encouragement of why you want to do a will, you determine who your property is going to go to. The court is not involved in that process if you have a well-drafted will. So the second part of an intestate probate is the administration of the estate. So we've determined who the heirs are going to be and how they're going to inherit, but how does that come about? There needs to be a gathering of the assets of the estate, and then a paying of the creditors or the debts, and then the distribution of those assets to the heirs. So, and that's a real abbreviated way to talk about an administration, because there are actually lots of steps to an administration. It's can be a very complicated process depending on what assets and what debts there are in an estate. So the first step to an intestate probate is to file that application to determine heirship and file the application for the administration. Now you will notice that here I have independent or dependent administration. There's a big, big difference between those two. And you don't necessarily get to choose which way you're going to go. And so I'm going to talk a little bit about dependent versus independent. Definitely, the most economical and efficient route is to have an independent administration, okay? And I'm having a little bit of trouble with my PowerPoint going. So there we go. So dependent versus independent administration. So a dependent administration means that a court has to allow you to make all of the actions that you're going to make in the estate, whether you sell real property or move property around. It is a very convoluted, hard way to do a probate. If you're going to make payments for payment in the estate, you have to get court approval to be able to do that. And it becomes very expensive because you end up going in and having court hearings. So you don't want to be in a dependent situation. So why would you have to elect a dependent administration, or why would you be made to do a dependent administration? If the heirs cannot agree on who the administrator is going to be. So maybe you have some children of the deceased person and they're arguing about who's going to be in control of the estate assets, because ultimately that administrator is in control of the estate assets. That's a reason that the court would make an administration be dependent. Another reason is if there are minor beneficiaries. The court is always going to have the best interest of those minors at heart, and the court will want more control over the probate when there are minor beneficiaries involved. So that would be a reason that you would have to have a dependent administration. But it could just be that the court does not like the fact scenario. Maybe the court has identified already that there may be some conflict in the future, or maybe there is a more complex estate with regard to the creditors or the assets. So for any reason that the judge determines a need for a dependent administration, you could have to have that dependent administration. An independent administration, though, will allow the administrator to serve independently without being under the scrutiny of the court. And so the administrator in an independent setting would be able to analyze the assets and the creditors and be able to go ahead and start paying those, maintain the utilities in a house if necessary. So they really have a whole lot more freedom. And of course, it's less expensive because you're not having to go and ask the court about every move that you're making. Now, step 2 in that intestate probate is where the judge appoints what's called an ad litem. That ad litem attorney is a separate attorney, and that separate attorney is paid separately from your probate attorney, and their job is to represent any unknown, missing, or incapacitated heirs. And so a lot of times families will come in and they're in a situation where they don't have a will and they're having to do an administration. And I will tell them about the ad litem attorney and they'll say, wait, we know that we're the only kids. There's nobody else out there but us. And of course, I know that's true as well, but the court and the law in the state of Texas requires that that ad litem attorney be appointed just to verify those things. And so it's not a choice. This is a necessity that has to happen. So again, okay, somebody send me a chat and let me know that you can see me now. For some reason, we had a glitch or something, but hopefully you can see me now. Perfect. Okay. So we're talking about the attorney ad litem and how that's not really a choice. You can see how the dependent administration is becoming more expensive. You actually have a separate attorney there that you're having to pay to look for those unknown heirs that could potentially be out there. So how does the ad litem go about doing that? The ad litem will interview the family members. They may talk to friends. And they also are going to approve the witnesses. There are going to be 2 witnesses that will need to come forward and offer testimony regarding the biographical history of the person that has passed away. And so this person is really digging into the family history to make sure that there are no kids that the people didn't know about, the family didn't know about, or any type of heir that would be unidentified. Now, step 3 is to have a court hearing on the applications. So you're asking the court to determine who the heirs are and then to appoint that administrator to be able to administer or handle the estate assets. And so once the administrator is appointed, the book of laws that control probates in the state of Texas is the estate code. And the estate code dictates exactly what that administrator is supposed to do in that administration of the estate. So the first thing that you're going to do is take control of and manage estate assets. And that may seem very simple and very easy, but the truth is sometimes it's hard to even know what are estate assets. Is everything that somebody owned at the time they passed away an estate asset? And the quick answer to that is usually not. There are usually estate assets and non-estate assets. So an estate asset is an asset that was owned by the decedent, and we're calling the person that's passed away the decedent, that's owned by the decedent at the time of their death that did not have a beneficiary designation or a survivorship arrangement. Okay, and I'm going to talk a little bit more about that survivorship and beneficiary designations whenever I start talking about estate planning here in a few minutes, because that's a really important part of being proactive in your estate planning before you pass away. So we'll focus on that a lot later. But just to kind of give you an overview, things that normally have beneficiary designations or survivorship arrangements are things like life insurance policies, bank accounts, retirement accounts, investment accounts. if you have a beneficiary designation, let's say on a life insurance policy, that money will bypass the estate entirely. So it goes directly to that beneficiary. And let me kind of tell you how that works as a practical matter, because a lot of times that's a question that people have. What do I do when somebody passes away with regard to the life insurance proceeds? Because maybe I need that money to be able to pay for a funeral, or maybe I need that money to be able to maintain the mortgage payments for a period of time. So typically the way that it works is you will contact that life insurance, the company that holds that policy, and they will request that you send them a certified copy of the death certificate, which the funeral home should help you coordinate getting those certified copies of the death certificate. And they will send you some administrative paperwork to complete for them. It may be a couple of pages. And you're going to complete that paperwork and send in that certified copy of the death certificate. And it should be very quickly that the beneficiary is issued the money from that policy. Now, a lot of times people get frustrated because the insurance company won't even tell them who the beneficiary is, or the retirement company won't tell the person, the family, who the beneficiary is. And the reason why is they are waiting for someone to have the authority as the administrator to be able to get that information. But regardless of whether you know who the beneficiary is or not, you can go ahead and start the process of sending them the certified death certificate and filling out their paperwork, and they should go ahead and issue the check right away to the beneficiary. So you can see where identifying what is in the estate can actually be a little bit tricky. And so there are several other steps that you're going to be doing as an administrator, and you can see the legal notice. And that used to be a great fly-in on my PowerPoint presentation, but we're a little bit limited technically here. So you're seeing it over the top of the other ordered steps. But once the administrator takes control of the assets, and bear in mind, that's an important duty that you have as the administrator of an estate. You have a duty to protect those assets. And a lot of times people are I see my camera's okay. For some reason it's glitching for us, but I think I'm back on. Okay, so you're compiling an inventory as an administrator. That doesn't mean that you have to go in and list every single piece of furniture in the house or every single thing hanging on the wall. That's not what we mean by an inventory. You can give estimates for what the total personal property is, but you're going to see on the inventory any bank accounts that didn't have a survivorship arrangement, or any accounts that didn't have a beneficiary designation. You're going to see real property. And when I say real property, I'm talking about homes, land, mineral interests, things like that. So once that happens, you've got all the estate assets identified. You begin to identify the estate creditors. And that can be a tricky process. Not only do you have creditors that you actually know are out there, like, for instance, a mortgage company. You may know that I know that there's a mortgage company, but you may not know that there are 2 credit card companies out there that the estate owes money to. And so in an effort to try to capture all of the creditors, the estate code requires that you publish notice to creditors in a local newspaper. And so you can see an example of that legal notice. Some of you may have seen those in the back of the Chronicle or something. You can see those legal notices, lots of them. And it's because they're a requirement by the estate code. So that lets creditors know that someone has passed away and they can file a claim if they want to. So you give notice to creditors, you give notice to any potential heirs, so the people that are going to inherit the property. Once the creditors are identified, then there is a process which is delineated by the estate code wherein you organize those creditors in a particular order, and then you pay them from estate assets. And once all the creditors have been identified, then you are able to distribute the property from the estate to the heirs. So you satisfy creditors first, and then you distribute that property. Now, it may not seem like it, but I have oversimplified that process just a little bit. I would always recommend that you get an attorney involved, because as an administrator, if you try to do it on your own, if you do not classify the property correctly, if you don't order the creditors correctly, if you don't give people notice correctly, you can have some personal liability there. So you don't want that. Now I'm going to talk a little bit about testate. What if you pass away with a will? How does the process work? You're going to see right off the bat, the process is much, much easier, and it's much less expensive. First off, we don't have to have a determination of heirs. We already know who's going to inherit the property from the will. So there's no determination of heirship, and we are able to administer the estate with the executor that is named in the will. So there's no fight, or there shouldn't be a fight or an argument about who is going to be the executor of the estate, because that person is already named or should be named in the will. And a big important part of a will is to be able to name that executor to act independently and without bond or security. And the reason that's big is we don't have that court involvement of the dependent administration that you would normally see in a dependent administration. The testator or the decedent is authorizing that executor to act without that court oversight. So a lot of times people will say, well, I did a will, and so do I really need to have a probate? Yes. Just by virtue of you preparing a will does not mean that it automatically transfers your property when you pass away. You still have to have a probate done to transfer ownership of your home or to transfer ownership of the assets that are in the estate. And this next slide here, it's a big one. Can you try to do a probate on your own? You can. Don't do it. Don't do it. I can't tell you how many times over the years, and I've been practicing law for 18 years now. I can't tell you how many times over the years people have tried to start the process and they are not able to do it, or they run into trouble, and we have to come in and try to undo what has been done improperly or start over on the process. So it's a good idea to at least consult with an attorney to kind of give you the steps to go forward in or identify areas that may be problematic for you if you try to do it on your own. So the first step, if you pass away with a will, is locating that original will. And the original will is important because if you have a copy of the will, then you're going to have witnesses that come to the courthouse that, I see a chat here. Does it depend on the complexity of the estate? So let's see, Chris had a question. There's an attorney versus online forms that are available. Does it depend? I can restart the camera. Perfect. So if I'm saying, okay, I'm going to try to do this myself, maybe there's only a house in the estate, go sit down with an attorney. It's worth at least paying a consultation fee to an attorney just to let the attorney say, yes, from what you're showing me, it appears that there's only a house in the estate, and maybe an alternative to probate would work for you. And I'll give you an example, and we'll go over this in a minute. An alternative to probate, if you just have a house in the estate, is you could probate the will as a muniment of title. And everybody at that point says, what was that word you said? And you're going to see it here in a minute, but it's muniment of title. and it is a much more efficient form of probate where you don't have an administration. So safer always to have an attorney, just because you don't want to be liable for something that you've done incorrectly, liable to a creditor or liable to another heir that may think you've mishandled the estate property in some way. So check with an attorney just in case. And then if you feel comfortable going forward after talking to the attorney, you can try to do that. So after you locate the original will, then you file an application for probate and for issuance of letters testamentary. And those letters testamentary are really the key to the kingdom. You know how I told you, if you have an account and that account doesn't have a beneficiary designation or a survivorship arrangement, these letters testamentary give you the authority to be able to talk to the person that's holding that account and to be able to have access to that account. So that's a big important part. Then you go in and you have your hearing on the application for that probate. So that's where the court's admitting the will to probate and appointing the executor to be able to receive those letters and handle the estate. And I'm going to show you now the steps. You can see a lot of the steps here are kind of the same steps that we had in the administration. You're taking control of and managing the estate assets. You're making the inventory. You're looking at all the creditors and looking at their claims, and you're ordering the creditors up. And Chris, back to your question, if there are creditors in an estate, right off the bat, I would not try to go forward on my own, because they are going to be watching. The ordering of the creditors is very, very important. They have to be paid in a certain order. And if you do not pay them in that particular order, you're looking at some personal liability potentially there. And so you're giving notice to creditors, notice to the beneficiaries. And once the creditor claims have been satisfied, you're distributing the assets of the estate to the beneficiaries under the will. Now, we talked a little bit about alternatives to probate. This is a wonderful thing in Texas. It affords you the opportunity, if you fall into certain categories, to be able to avoid a full probate, okay? But you have to fit into certain scenarios in order to avail yourself of this. So the first one is a small estate affidavit. This small estate affidavit is a situation where a person has passed away without a will, and the estate has very little debt, and the estate only really consists of a homestead and a very small amount of personal property. Then a surviving spouse or a minor child can actually have a small estate affidavit or file a small estate affidavit to be able to manage the estate. And you can see it just by virtue of who you are. If you're not a surviving spouse or a minor child, it really limits your ability to be able to use this particular method. We don't see it very often. Typically, the children are grown, and there's too much in the estate to be able to do this particular one. But it is a possibility if you fall into the category here. Next is the affidavit of heirship. An affidavit of heirship only transfers real property. So that's houses and land. It's not my preferred method of taking care of real property and land if somebody has passed away, because you always run the risk a third party may not accept it. Typically they do in the state of Texas, but when I say third party, I'm talking about a title company, for instance. So if your dad passed away and an affidavit of heirship is done because he didn't have anything else but the house that he was living in, I want to know that if I try to sell that house later, that the title company is going to accept that affidavit of heirship as having transferred the property to me. So a better method is, if you have a will, to probate the will as a muniment of title. So if there's no debts in the estate and you're wanting a guaranteed transfer. There's no question whether or not the property has transferred from the person that's passed away to the person that is supposed to receive that property. Okay, I think I'm back online. So this is a judge's stamp of approval, and of course, third parties know that they can rely on that. Now, I'm going to talk to you a little bit about being proactive, okay? And this is really perk up here, because if you have the ability to be able to do your estate planning, you have capacity, or your loved one has capacity, you're going to want to make sure that you do as much as you can right now to make this process very easy, very economical, and very efficient whenever they pass away. So big number one is update beneficiary designations. So you know how I told you life insurance policies, for example, they have beneficiary designations. A lot of times a spouse will pass away and those are never updated. Huge. Update those, because if there is no beneficiary designated, that money is going to go into the estate. And so you want to try to keep that out of the estate as much as possible. So you're updating those beneficiary designations, and get a copy of them. And the reason that you want a copy is you don't want to have to rely on that third party to disclose that information to you when the time comes. You want to be able to go to your safe, pull it out, and know exactly who that beneficiary is that's designated on that particular asset. The next is make elections on your bank account. When you go into your bank, you need to put a pay on death on your accounts. Now, I'm not telling you just to add somebody to your account that's not safe. You don't want to add somebody to your account because it creates a liability situation for you. So if I add my child, my adult child, I'm calling them child, but if I have a child that's reached majority and I add them to my bank account, if they get into a car wreck and rear end somebody, it could be a liability situation for me because they are in ownership of my account. Now, the pay on death that I'm telling you to put on your account is safe because that child has no ownership of the account until you pass away. So that is perfectly safe to designate them as a pay on death. If you have a joint account with your spouse, you want to make sure that that account is designated as a joint right of survivorship. So very important. Again, that is going to keep those assets out of the estate. Also, it gives you the opportunity to have immediate access to those funds, which would be huge in a lot of situations because maybe you need to keep the lights on in the house so you can go through the house, or maybe you need to make a payment on the car. You have immediate access to those funds with a certified death certificate. Next thing, make a list of all accounts that you have. Put online passwords for Facebook, emails, put credit card companies down. This makes it so much easier on your family if something happens to you, because they don't have to dig through boxes to try to figure out what you had where or what life insurance policies you had. They are able to go to the designated spot and find that list of assets or debts that you've kept and hopefully maintained, pull that out, and they're not waiting on the mail to come in. If you think about life insurance policies, I can tell you I've seen situations where life insurance policies typically renew maybe once a year, and family members will have no idea that the life insurance policy is out there. And so they wait, they finish up everything that they think they had to do, and then a year later they get a notice there's a life insurance policy, and that money could have been really helpful early on. So make sure that you list those things out for your family members. And you can also do handwritten instructions for personal items. This is, I'm not talking about for leaving houses or cars. This is for things like maybe you have some furniture in your house or your clothing. You can list out who's going to get those things in your own handwriting, sign and date it, and the court can take judicial notice of those things. Now, documents that are important in estate planning. So what would the attorney prepare for you in an estate planning situation? And let me see, I have a slide. There we go. Okay. So number one is the will, and we've kind of talked about the importance of the will already. The will distributes your property after you pass away. Very important. It allows for the probate to be more efficient and easier. It's you choosing how you want your property to go. And then there are two power of attorneys. The medical power of attorney, and these power of attorneys are used not when you've passed away, but if you are still living, but you become incapacitated. So that medical power of attorney allows someone to make medical decisions for you and access your medical records. The statutory durable power of attorney allows someone to handle all of your financial matters. If they need to sell a piece of real property to get skilled nursing care for you, they can do What is the alternative? And this is a question that I get. What is the alternative if I have these documents? The alternative, if you do not have these power of attorneys, is a guardianship in the state of Texas. And it is a legal process. And it typically is much more expensive than doing the power of attorney. Not even typically, it is much more expensive than doing the power of attorneys. You have third parties that are involved. And I don't want to be a discouragement to you if you are caring for someone that does not have these power of attorneys. I'm guessing fairly quickly you're going to see that you need some authority to be able to make decisions for your loved one. If you don't have the power of attorneys, don't be discouraged. Call me. I'm happy to help you work through a guardianship. We're specially certified as attorneys to be able to do guardianships, and I have that special certification. But if you're in a situation where your loved one or you can execute these power of attorneys, do it. It is much, much less expensive, and it can be turnkey, where when your loved one loses capacity, you can pick it up and you can immediately start acting as their agent, okay? That fourth document that you're seeing there is the directive, and this is the directive to physicians. This is where if you're on life support and there is no hope that you're going to recover, there's no brain activity, and the physicians come out and they say, we need to unplug him. Typically, your medical power of attorney is going to have the authority to sign to unplug that life support. But where the directive is helpful is, number one, that takes the it's pretty emotionally traumatic to have to remove life support from someone. So it takes that off of the plate of the medical power of attorney. They can just give the directive to the doctor and say, he has already made this decision. Another way that it's helpful is there may be a situation where there are 4 or 5 people in that waiting room and they're all arguing about whether or not to unplug. It nips that in the bud because you have already, you've already made that decision. And so I see a question here from Chris. Would a power of attorney capability differ in the one you need to take care of if they live in another state? Good question. And that's actually on my question list. I get that question a lot. And the answer is typically the directive will work from state to state. That should be recognized at any hospital in any state, but that's just the directive. And let me say that again, that is just the directive. And the reason I say that is states have different laws with regard to these estate planning documents that we're talking about: the will, the medical power of attorney, and the statutory durable power of attorney. So 100%, and hear me say that, 100%, if your loved one lives in another state, or let's say you have a loved one that was living in Texas, they got their documents prepared in Texas and they're moving to a different state. Absolutely. Have an attorney in that state review those documents to make sure that they comport with the laws of that particular state. That's huge. And the reason it's huge is because I don't want anybody to go forward holding on to documents and relying on documents for authority that they really don't have any authority at all. It is worth a consult. Quite frequently, people that have relocated to Texas will come in and have me review their documents from other states. And sometimes I say, yeah, this document's going to work. It meets all the requirements from the state of Texas. A lot of times it does not. To give you an example, a really common example that I see a lot is other states will not say that the executor in a will can act independently and without bond or other security. Well, we've already seen where that's a real important part of what we do here in probates in Texas. You don't want to have court oversight unless you absolutely need it. And so you don't have that option if it's not particularly delineated in that will. And so it can be very, very important. Now, I'm getting close to running out of time here, so I'm going to switch gears just a little bit, and I'm going to answer some of the more frequent questions that I get at these conferences. So people will say, do I really need a will? Maybe I don't have any property right now. The answer is most people acquire some kind of property before they pass away. Get a will. Get a will. If you are a younger person and you have minor children, estate planning is huge for you. You don't think about it, but you're trying to name guardians for your children in case you become incapacitated or in case you pass away. So I always tell people wills are very important. It's better to have it and not need it than it is to need it and not have it. So is probate necessary every single time? Like I said, most people do own some kind of property whenever they pass away. But my suggestion is always come in and just do a consult with an attorney just to make sure that probate is not necessary. I'll give you an example where probate may not be necessary. And I see my camera's going off here just a second. Okay, so if someone is in a nursing home and maybe they have already given their home away to their children, and so maybe the only thing they have is a checking account. If you've gone in and put a pay on death designation on that checking account, there may not be a need for probate because they didn't own anything at the time of their death. So just identifying, making sure that you've been proactive from the get-go and putting those pay on deaths. Probate may not be necessary, but most of the time in my experience it is. Can a person have the same individual be the executor in their will, their trustee in their will, and the agent on their power of attorneys? Absolutely. Absolutely. You can have the same people. You can have different people. My recommendation is, though, that you not only have a primary, but you have a secondary in those positions. So if I'm listing, and an executor is the person that wraps up the estate and pays the creditors if you've passed away. And your agent is the person that operates under your power of attorney. So you're still living, but you're just incapacitated. You can choose whoever you want as long as they're of the right age to serve in those capacities. But the reason you're putting a secondary is, what if they, okay, I saw a little chat come up, but maybe not. So what if they pass away simultaneously with you? Or what if they pass away before you do? You want that secondary to be able to kick in. You don't want your power of attorney to not be helpful to you because there's nobody living that can serve in that capacity for you. A lot of times people will say, well, can my loved one sign a will? I'm not really sure. They're in an assisted living facility, or maybe they're being cared for at home, and maybe they're lucid in the mornings. Maybe they understand things better in the morning. I can tell you that not only am I an attorney, but I'm a notary. And we, of course, have a notary in our office. What we do to determine if somebody has capacity to execute a document is make sure they understand what it is they're signing. And I will tell you always, I will work with the family. If you tell me they're going to understand in the morning, but as the day progresses, they get more confused, they're probably not going to understand, we'll accommodate. I've gone into assisted living facilities and nursing homes first thing in the morning so that I can make sure that there is, the best possibility for analyzing the capacity of the person that's going to sign. So really, just if you're on the verge, you're not really knowing if they have capacity or not, move very quickly, because we don't want them to lose the capacity that they have to sign. Move very quickly. Come in, talk to us, and we will go out and assess capacity and competency for you. If I'm the executor, do I have the authority to take estate assets away from family members? Not only do you have that authority, but you have that duty to do that. So yes, and that is once you've been appointed and you've received those letters that give you that authority, the letters testamentary or the letters of administration. Very quickly, last thing, because I only have a couple of minutes here. I know that caregivers, a lot of them have been very challenged here in COVID times with access and, just being able to receive information about their loved ones. And I want to tell you, if you have power of attorney over your loved one, whether it's the medical power of attorney or the statutory durable power of attorney, you have the right and the ability to be an advocate. And let me give you an example. When I go in to the courtroom as an attorney, I know the authority that I have because I have the law on my side that I'm working with, and I'm applying the law that I have to the facts that I have. You have that kind of authority by law to advocate for your loved one if you're their agent on the power of attorneys. So it is very, very important that you know what power and authority that you have. Many times I'll have people call and they'll be really panicked. They'll be in a situation where they feel powerless and they'll say, I don't know what to do with this third party that won't let me in the room, or they won't let me make this decision, or I don't know what to do. I can't get this money released for my loved one that I'm caring for. And I say, do you have authority under a power of attorney? And they say, well, yes, I'm the agent under the power of attorney. But guess what? They've never really, if they've read it, they never understood what their authority was under that document. And so exercise, be educated, educate yourself on what authority that you have and walk in that authority. Walk in knowing that you have the power to advocate for your loved one under that power of attorney. And if you don't have a power of attorney and you're having trouble getting access, making decisions for your loved one that's incapacitated, get a guardianship, become their legal guardian. All right. So be encouraged. And today you've got some really great speakers that are going to be actually going to have a panel discussion at 12 o'clock where you can be live like you are right now and ask questions to a panel of people. But some of the people are going to give you some great information for self-care and community. Community is so powerful. It's so powerful because there are people that are struggling and are facing the same exact challenges that you're facing right now. And a lot of times they have discovered who the resource is to help with this particular question, or how to navigate this troubled water. So it's important that you link up with a community of people that are similarly situated so that you can navigate this together. And that's why these caregiver conferences are so huge, is you have the ability to have support and, community from people that know what you're going through. So again, my name is Charioty James, and I'm an attorney with James and Parlange Law. I'm located right here in Kingwood. and you can give us a call at 281-358-8836, 281-358-8836, or you can look us up online, www.jparlaw.com. I'm so happy to help you any way that I can. And if you just need to brainstorm, don't hesitate to call us up. I'll try to help you any way I can. Thank you so much for joining us today. And again, we're going to have that panel discussion at 12 today. So feel free to join in on that.
Real quick, Charity, there's a couple of questions if we can maybe touch on those real quick. It was, what happens if durable POA has passed due to cancer and there's no secondary? Both parents are not of capacity to change or sign a new POA.
Okay, that person is going to need to come in. And the reason why is just from the facts that you've given me, it appears to me that they're going to need a guardianship. If there is no secondary listed and both parents have lost capacity to sign, you're probably going to need a guardian appointed. And so we didn't really go into the guardianship or the process of a guardianship today, but I'm happy to sit down and tell you what the entire process is and help you navigate through that.
Perfect. And then the last question, and then we'll wrap it up, is a handwritten will that's notarized sufficient legally?
That's a loaded question, Darian, and the reason why is there can be a lot more defects to the will than just it being notarized and in handwriting. So my suggestion on that would be let an attorney look over it. I wish I could say, yes, that's going to work for you, but it has to have testamentary intent. It has to be dated. You really need it to talk about allowing the executor to operate independently and without any bond or other security. So there are a lot of little ticks that would be important to be included. So I wouldn't rely on that as an attorney. I'm not going to tell you to rely on something that somebody has handwritten and notarized just because it's probably going to have some defects. It might work, but you may have some extra steps added to the probate.
Perfect. Thank you so much, Charity. And thank you, everyone else. We'll be back at 10 with the next session. And then, as she mentioned, we have the Q&A panel at noon. So we'll see y'all soon.
Thank you so much.